of evidence the prosecution had during trial was taken from the Anthony's family home computer. They said that they found 84 searches on the hard drive for chloroform. But during trial, according to the New York Times, the owner of the company that created the software that extracted that information from the hard drive said that the software was faulty and there were not 84 searches, there was only one. We attempted to contact the prosecutors to ask them for their reaction to this. They did not respond to us, nor did they respond to the New York Times. Remember, it was that chloroform search that was a linchpin of the prosecution's case because they claimed that Casey had poisoned her little daughter, Kaylee, with chloroform. Ann?
All right, Carrie Sanders this morning. Carrie, thanks. Star Jones is a former prosecutor and veteran legal commentator, and Savannah Guthrie is today's legal correspondent. Good morning to both of you.
Good morning.
On this last point, is it possible that the prosecution failed in its duties while during the trial it discovered that it wasn't 84, according to the same software designer who said it was 84, but in fact when he checked the data and checked and discovered glitches, it was only one time that there was a chloroform search?
Law and ethics require the prosecution to turn over any information that might be exculpatory to the defendant. If they found out prior to the close of their case that what was considered a linchpin, if you will, of their case, there was material that suggested that they put on false evidence, in theory they should turn it over to the defense.
Yeah, if it's exculpatory evidence, they should have turned it over. What I think is interesting here is there was testimony from a different search engine company that said it was only searched one time. So the jurors did hear this evidence that it wasn't 84 hits, it was only one. One thing, though, I remembered, because I think I commented on the time, you know, in the closing argument by the prosecution, they never mentioned those computer searches. And I remember thinking, that's odd. That was their key evidence of premeditation. Right. So why did they drop the issue in closing arguments? This may be the reason why.
Well, this is an argument. If you know or you think there's material that went in before the jury that should not have gone in, if you don't use it as a part of your closing statement, then that's a good suggestion that you knew there was some problem.
I wonder if that's why.